So welcome, everyone. My name is Peter Zimroth. I'm the director of the Center on Civil Justice at the NYU Law School. For those of you who are new to the center's events, just a word about the center. This center is dedicated to the study of the civil justice system in the United States and how it can fulfill its purposes. The center's mission is to study and to improve the civil justice system in the United States. Some of the most distinguished judges, lawyers, and scholars in the country sit on the center's board, and a roughly equal number of plaintiffs and defendants lawyers. You can see the full list on our website. The center has dedicated a very substantial effort to studying aggregate litigation, especially class actions and multi-district litigations. In 2014, the center hosted its first major conference on consumer class actions. Since then, we have either hosted or co-hosted a 2016 conference commemorating the 50th anniversary of class actions, a 2017 conference with the University of Montreal entitled The Class Action Effect, a 2018 conference commemorating the 50th anniversary of multi-district litigation. In 2019, an event on legal and regulatory issues raised by the opioid epidemic, and also a discussion with Professor Brian Fitzpatrick about his new book, A Conservative Case for Class Actions. And several publications and projects have come out of these events. A volume in the NYU Law Review on the 50th anniversary of Rule 23, a short publication transcribing Professor Sam Zakharov's interview with Professor Arthur Miller, both professors at the NYU Law School and both members of our board, on the drafting of Rule 23, a book of papers on Canadian and American class actions. We have also several ongoing projects. We've been engaged in a multi-year project to increase transparency in aggregate litigation cases, and we are putting together data templates that standardize data collected by claims administrators. And our hope is that judges will issue orders requiring this data to be reported for those cases. With this data publicly available, academics and policymakers will be much better able to determine what is and what is not working in these aggregate cases. So just a word about today's event. In February, Tony Seeback, a professor at the Cardozo Law School and a distinguished fellow at the Center on Civil Justice, moderated a panel on which both of our featured speakers today participated along with our board chair, Sheila Birnbaum. There was a very spirited discussion about class actions, and both our speakers today wanted to continue that discussion. So here we are. A few preliminary announcements before I introduce our moderator today. This event is approved for 2 CLE credit hours. To receive credit, you will need to submit a form that we will send to you and include 2 codes. Those codes will be given at 2 points during the discussion. Please write them down. We will also be fielding questions at several points during the event. Please type them into the Q&A box at the bottom of your screen, and David will curate them and read them aloud, making sure that we're not just repeating the same questions, so that he will try to curate them. So now I want to introduce you all to Judge John Koeltl, who will be moderating this event. John Koeltl is one of the best respected trial judges in America. He's also a very dear friend of very many years and a member of our board. After graduating from the Harvard Law School, Judge Koeltl clerked for Judge Edward Weinfeld in the Southern District of New York and Justice Potter Stewart on the United States Supreme Court. He became an assistant special prosecutor for the Watergate Special Prosecution Force before joining Debevoise and Plimpton, where he became a partner. In 1994, President Bill Clinton nominated him to serve as United States District Judge for the Southern District of New York, where he has been sitting ever since. John, I'm very, very happy that you agreed to do this, and I will turn it over to you. I hope everybody has a terrific time today.
Thank you, Peter. It's a pleasure and a privilege to moderate the panel. We have a distinguished panel to discuss the multi-district litigation process. First, Professor Elizabeth Burch, who is the Fuller E. Callaway Chair of the University of Georgia School of Law. She has published over 30 articles, essays, and a casebook. Most recently, she published a comprehensive review of multi-district litigation relating to mass torts, entitled Mass Tort Deals, Background Bargaining in Multi-District Litigation. Second, and alphabetically, is Chris Seeger. Chris is a founding partner of Seeger Weiss, one of the leading plaintiffs' attorneys in the area of complex and mass tort actions. He is a member of the Board of Advisors, as you heard, to the NYU School of Law Center on Civil Justice. It's reported that between 2016 and 2019, he received more MDL appointments than any other plaintiff's lawyer. So a distinguished and knowledgeable panel. Our focus today is on multi-district litigation and the process of that litigation as it relates particularly to mass torts and how it can be improved. But before we talk about improvements, we should have a good grounding in how the multi-district litigation process actually works, how the judicial panel on multi-district litigation proceeds, what distinguishes mass torts from other types of aggregate litigation, the differences with class actions, and how those cases can be litigated and settled. So let me turn first to Chris to set the table and then have Beth comment. I should add, we've agreed to use what I refer to as the Aspen rules. I'll refer both to Chris and Beth by their first names, and they're welcome to refer to me by my first name, even though none of us would do that if we were actually in court. So, Chris?
I'm not sure I can bring myself to do that even here, so I'm
Feel free.
Call you judge. Okay, so I'll set the table. I was going to do a brief overview of, basically what an MDL is. I would go through that. I was going to talk a little bit, and I will talk a little bit about the statistics and my understanding and my belief, and which I think is shared by others, about why we've had this big explosion in MDLs since the 90s. So I'll start with that. And then if I leave anything out, Beth will cover it, or Judge, you'll prompt me with a question if that's okay. So I looked quickly at the participant list, and judging by the names I recognize, this will be familiar for most of them, but for a few who might be on and are not familiar, An MDL is a creature statute. The statute is 28 USC 1407. And the purpose of centralization of federal cases before one judge is to achieve judicial efficiency in pretrial proceedings. Cases need to have one or more common questions of fact that are pending in different districts, and transfer is intended for the convenience of the parties and witnesses with the intention of promoting just and efficient conduct of the transferred actions. Interestingly, which people who don't live in the MDL world might find interesting, is that cases can be centralized in a district where a defendant may not be amenable to personal jurisdiction or venue. And there have been thousands of litigations that have been centralized involving hundreds of thousands of claims, like the asbestos litigation, BP environmental case involving the Gulf Coast. In the 3M litigation, there are 200,000 claims alone there. The VW diesel litigation, these are all names people probably know. There were over 500,000 individual claims. In the NFL concussion litigation, again, about a class size of about 22,000, and in Vioxx, about 30,000 individual claims. So these are massive cases. And there's some interesting statistics that I thought would kick this off, because people might be scratching their head saying, why is everybody so interested in this? And since 1968, the JP MDL, that's the panel that centralizes these, which involves 7 judges, I believe, appointed by the Chief Justice of the Supreme Court, has centralized, and these are old numbers, so these numbers are probably bigger, over 700,000 civil actions. Of the over 700 civil actions that have been centralized, only about 16 or 17,000 have actually been remanded to the transferor courts. And Beth, you might be more updated. Some of these numbers are a year or two old, but approximately 500,000, 500,000 claims or more have been terminated with the transferee judge, either by dismissal or settlement. So since 2019, which is the most recent data I could find in a quick search, the MDL cases constitute about 52% of the civil caseload in the federal district courts. So I guess the question is, so why the big explosion and why all this? And I took a look at the nutshell that, and I've discussed this with others, but the nutshell that was drafted and created and published by Bob Klonoff, because I trust Bob, he's a trusted source and he tracks these things. And he made 2 interesting observations, which I agree with. I think one of the biggest driving factors is that in the light of the AmChem, the 2 Supreme Court rulings, AmChem and the Ortiz case, it became incredibly difficult to maintain personal injury cases as a class action. I say difficult, maybe a few years ago I would have said impossible, but we have certified and maintained a class action in the NFL concussion litigation. So I think we've proved it's doable, but it is still very, very difficult. And that's led to an explosion of cases being handled through MDLs that involve mass harm. So we live in a consumer society. We make products that are bought and used by millions and millions of people, pharmaceutical products that are used by millions and millions of people. In the Vioxx litigation, I think there were well over 22 million individuals who had ingested Vioxx. So you're going to have, as a result of a product that may go bad, you're going to have mass harm from that. Another factor, which Bob, I didn't focus much on, but I noticed that Bob did in his book, was the Supreme Court decision allowing lawyers to advertise. So acquiring cases, especially in the age that we live in now with websites and online marketing, you know, it used to be that getting cases was a barrier to entry because they were relatively difficult to come by. They would be referred to you by a lawyer who was usually a local lawyer who was known in his town. He couldn't handle the cases because they were either too expensive or maybe just more complicated than he wanted to get involved with. But today, pretty much anybody can put up a website and get cases. So those are 2 factors. That's pretty much the overview that I was going to provide. Beth, if you want to pick it up from there, or Judge Koeltl.
No, Beth, do you just want to comment on the background before we get to the issues of any problems and the possible improvements?
Well, I can work it in. I have some statistics, and I think I have some statistics that'll answer the question that was posed in the Q&A. So I'll get there in just a minute, but I'm happy to defer to you if you'd like to comment.
Okay, so one focus that we wanted to use today was on improvements in the process of dealing with multi-district litigation involving mass torts. But without some understanding of the current problems, it's difficult to talk about improvements. We can all do better. As you've heard, the Judicial Panel on Multi-District Litigation was established by statute in 1968, over 50 years ago, before the explosion of litigation that we've seen, particularly in products litigation, leading to hundreds of thousands of claims and in some cases. 50 years is a long time. In her book, Beth points out that all is not well in the mass torts world. She compares the litigation process, particularly mass tort litigation process, to a car that started off as accommodating some passengers and now is being asked to accommodate groups that could be fit into a stadium. So Beth, could you sort of expound on the current problems that you see in the process before we turn to ways that we might improve the process?
Sure, I would be happy to. So, I'll just say as a starting point that I do think that MDL serves a really worthy purpose. It demands a ton of creativity from judges. And so most of the time, judges don't have the luxury of that I do, which is to sort of sit back and kind of take a bird's eye perspective of the system. So I'm going to just share a screen here real quick with a quick PowerPoint. Hopefully that's working. Can everybody see that okay? Is that working for all?
Yes.
Okay, so 30 years ago, Deborah Hensler posed a number of questions that we still don't have the answers to. And so, I just want to sort of start from the place of saying that there's a lot that we don't know. And there may be a lot that the lawyers that are involved in the proceedings know that I don't, as just sort of an outsider to the process. So the first big question is, how do we compare outcomes? How do we look at class action proceedings as opposed to non-class proceedings? How much money actually gets paid out in these non-class settlements and to whom? How does claims administration look in the class action process versus in non-class proceedings? Are like plaintiffs treated similarly? How much does it cost to deliver benefits in, say, a class action deal versus a non-class settlement? So these questions have proven impossible for me to answer. I'm extraordinarily appreciative of the NYU Civil Justice Center's work in trying to gather this data. It's a lot of different data points. But to the extent that judges can help collect this data, it would be really nice to know what the substantive outcomes actually look like. So what that leaves me with is not looking at the substantive outcomes, but looking at the procedural inputs, right? We can look at the procedures that go into all of these things and hope that if we have fair procedures that we will then have fair outcomes. Of course, as we know from the class action, even when you have all of these due process protections, it's not an assurance that everything is going to be perfect or completely smooth. But when MDLs proceed without class actions, then they lack all of those structural protections that have been built into Rule 23. So when judges appoint lead lawyers, they don't typically consider adequate representation ideals, even though the plaintiff's claims and injuries may vary relatively significantly. Judges don't have the formal power to review the settlements that come out of these private deals in the same way that they do in class actions to make sure that they're fair, reasonable, and adequate. There are very few appellate opportunities, and there are no formal paths for objecting, and some judges have channeled all communication through the lead plaintiff's lawyers that they appoint. So the principal agent problems that we have long talked about in the class action context don't magically disappear when aggregate litigation isn't certified as a class. Instead, these tendencies can be exacerbated if there are repeat players in the leadership, which of course there are. Now, that's not surprising in and of itself, right? Attorneys specialize all the time, and it could be that they're using their expertise to generate better outcomes for the client. That's certainly what we would hope. The worry that I have, though, is that playing the long game may mean developing working relationships with one's opponent, such that each side can bargain for what matters to them the most from a self-interested standpoint. So for the plaintiff's attorneys, this is typically generating attorney's fees in the form of common benefit fees. For the defense attorneys, this means creating the most closure with the least money possible. And so in particular, I am worried about whether the lead lawyers are adequately representing all of the plaintiffs and whether the deals that they negotiate might undermine the plaintiff's consent to settle. So I have a quote up here from an ongoing study that I'm doing, which is talking with a number of women who have been involved in women's health MDLs. But it raises the concern for me that the procedural concerns, the inputs, may also infect the legitimacy of the outcomes. So unlike class actions, which gain legitimacy from complying with all of those due process checkpoints, when MDLs conclude through these private aggregate settlements, the only basis for the settlement's legitimacy is the plaintiff's consent. There's no ability to correct error through appeals. There's no formal path for non-lead lawyers to object. And again, a lot of the judges channel information through the lead lawyers. So let me be really clear about this point, because I'm often cited erroneously for the idea that I don't like repeat players. My point is not that we need to eliminate repeat players. Instead, it's that we may need to build in some structural assurances of fairness to help make sure that there's adequate representation and to ensure that plaintiffs don't feel coerced into settling. So very quickly to answer the question, some of the questions on the data points. Some of this data is a little bit old at this point, but this gives you a snapshot as of 2019. I started collecting data on products liability and sales practices back in 2013. There were 73 total proceedings. And if you look here, you can see that products liability and sales practice make up about 1/3 of all of the MDL proceedings. But that's a little bit misleading, because when you look at the number of cases that are involved rather than just the number of proceedings, mass torts, right, particularly products liability, generally range between 89 and 95% of all of the MDL cases. So my focus has been on how do those cases end? And in particular, my focus has been on these aggregate settlements, particularly the settlements that don't end up through the class action context, but rather end up through these private deals. So to the extent possible, given that most of these settlements are private, I looked at all of the deals that were negotiated, these private settlements, and Margaret Williams, who I hope is on the call somewhere, she is a genius with numbers and is much better than I am at any of this, but she did this social network analysis. It allowed us to confirm that one of the top 5 connected repeat players participated directly in negotiating each of the settlements that we looked at. And typically what network analysis does is it gives us a sense as to what the complex connections look like between the people, in other words, the lead lawyers, and the events. So you can sort of see here, there are people and events in here. And if I switch out and just sort of look at the law firms, there are plaintiffs and defense law firms, and sort of the bigger they are, the more involvement they have in the proceedings that we looked at. So to look for advantages that repeat players might enjoy, I looked at the settlements to try to figure out if there were provisions that one could at least argue are more beneficial to the lead plaintiff's lawyers or to the defendants, rather to the plaintiffs themselves. And of note here, all of these settlements aren't the typical settlements that you would anticipate finding between the plaintiffs and the defendants in, say, a car accident case. Instead, these are settlements between the defendant and the lead lawyers, whereby the plaintiffs give up their right to sue in court to enter into a settlement program that may or may not ultimately compensate them. So quick caveat here, I know Chris can tell you more about some of these deals than I can. I'm looking at this data as an outsider. I'm not a plaintiff's lawyer. I'm not a defense lawyer. I don't consult for plaintiff's lawyers or defense lawyers. So I'll tell you a quick story that'll give you a sense as to what some of this data looks like. Propulsive will give you a little bit of context for the dry numbers. And I think Chris will be able to maybe spin out some of the other stuff that was happening in state court as well. But it illustrates how these deals work. So back in the 1990s, there were about 30 million people who took Propulsive for heartburn. Johnson & Johnson marketed it to pediatric hospital units for use in children that had acid reflux. Problem, of course, was that the FDA had never approved Propulsive for use in children. So in 1997, a top FDA official warned the company that pediatric patients may be at greater risk of cardiac problems, and it urged Johnson & Johnson to amend the label to warn doctors and patients. Instead, J&J's internal memos predicted that it was going to lose about $250 million a year in sales. And so it watered down the language, and it turned Propulsive into a cherry-flavored liquid for its, quote, elderly patients. Sales, of course, showed that about 90% went to children. Johnson & Johnson eventually withdrew Propulsive from the market in July of 2000, and the claims were centralized in front of Judge Eldon Fallon in New Orleans. Judge Fallon denied class certification. He granted summary judgment on a number of the individual cases. But Propulsive is important because the leaders in that case pronounced that they were creating a template for all future litigation. And they were exactly right. So all of the settlement provisions that I was able to examine show that the types of provisions that I'll tell you about in just a second get replicated and refined as litigations continue. So Propulsive's deal makers wanted to maximize closure, of course. So they said that if 85% of the death claims didn't enroll in the settlement program, then the deal was off. And in fact, I found these kind of walkaway provisions or blow provisions, as they're sometimes known, in 100% of the other settlements that I examined. There's been a slight evolution here. So there's a census or a claims registration provision, which requires all of the plaintiff's lawyers in an MDL to register all of their clients, regardless of whether they're in the MDL. It could be that they're in state court or that the cases aren't filed at all. And that then becomes the denominator for the walkaway provision. The second thing that Propulsive's designers did is that they created an opt-out form for non-settling clients. Now, this didn't allow you to opt out of the settlement, as you might think. Instead, it authorized counsel to withdraw from representing the clients who refused, meaning that the clients were essentially opting out of the attorney-client relationship. That becomes the template for more sophisticated provisions requiring attorneys to recommend the deal uniformly to their clients. 84% of the settlements included provisions like that. And then 53% took the added step of requiring attorneys to withdraw from representing plaintiffs who refused to settle. So out of the total fund was somewhere between $84 and $105 million. The medical records went to a panel of doctors. The doctors permitted or denied the claims without explanation. And so only about 37 of 6,000 some odd plaintiffs recovered any money at all through the claims process. And they recovered an aggregate amount of about $6.5 million. The lead lawyers negotiated their common benefit fees directly with Johnson & Johnson. And in fact, 84% of the settlements that I looked at, the leaders negotiated some aspect of their common benefit fees with the defendant. Now, of course, bargaining for your attorney's fees with your opponent is a stark departure from traditional contingency fee principles. Those principles are designed to tie the lawyer's fees to the client's outcome. Well, where does the rest of the money go? 8.3 million goes to Canada, 8.3 million goes to the Louisiana Health Public Initiative, and the leftover funds revert to Johnson & Johnson, somewhere around $45 million. So about 23% of the settlements that I looked at included these reverter clauses. So I'm reminded in all of this of this Weinstein quote. But my worry is that after looking at all these settlements that occurred over a 14-year span, I was unable to find a single deal that didn't feature at least one of these closure provisions for defendants. And I likewise found that nearly all of the settlements contained some provision that increased the lead lawyer's common benefit fees. So in short, I found reason to worry that as repeat players are influencing the practices and norms, that they might be undermining the plaintiff's ability to freely consent to the settlement, which again, may or may not be affecting the substantive outcome. So Propulsit is an anomaly in the sense that it is one of the very few proceedings for which there is actual data on the substantive outcomes. So the question that I always get at this point is, what's the alternative, right? What are you going to do with it now? So I will just very quickly highlight some of these, and then we can talk about it more in just a minute. I'm reminded here of the Sixth Circuit's admonishment in the MDL that MDLs are not some kind of judicial border country where the rules are few and the law rarely makes an appearance. So what I have been thinking about is the way that we can recognize the really important gaps that MDLs fill, but we can reintroduce some guardrails that can help effectuate both the individual rights and the state rights on which the procedures are based. So the first thing that I would encourage courts to think about is to use a competitive selection process on leadership selection, and to focus really on adequate representation, something akin to what we're seeing in Rule 23 for appointing lead lawyers even in non-class MDLs. The second thing, and we'll talk about this more in just a minute, is to think about putting in place some episodic remands, some points at which there are opportunities for plaintiffs to exit. Those benchmarks may very well vary by the proceeding, but they might occur perhaps at the beginning for plaintiffs with claims that fall outside of the proceedings that the lead lawyers plan to work up, and maybe for the lawyers at the end who decide that they don't want to enter into the settlement agreement. And then finally, I think maybe this is the most important for me, is to tie the common benefit fees to the benefits that's actually conferred on the plaintiffs themselves, as opposed to sort of the sticker price of the settlement fund. So tying fees to a settlement's merits really helps to realign common benefit fees with their basic contingency principles. Of course, the basic idea there being that the better that the lawyers fare, the better their clients fare. So I will stop there. I'm sure I've given Chris lots and lots to talk about.
Before calling on Chris, one of the things that you mentioned appears to be a criticism of repeat players, repeat lawyers who get appointed as lead counsel. And the question naturally comes to my mind of, even if you had some form of additional competitive process, when you look at adequate representation, even in the class action context, putting aside the largest financial stake in a securities class action, you would look to lawyers who have experience. You wouldn't, if you wanted brain surgery, go to a person who had never operated on the brain. If you look at lawyers, wouldn't you naturally go to lawyers who could say, I've handled any number of MDLs. I've handled cases where there were hundreds of thousands of claimants, and I brought the litigation to a conclusion before the judge, unlike in other cases where the MDL may simply be going on and on and on. Wouldn't that be an important, perhaps determinative factor for the judge to consider?
So absolutely, I think experience is important, and that's one of the reasons that I'm not anti-repeat player. I do think that we could add some diversity into the mix of repeat players, and the types of diversity that I specifically have in mind are cognitive diversity. Bring in people who might have helped really develop these cases on the ground and who might have insights into the way they work, but who aren't necessarily the usual MDL leaders who are selected time and again. So judges tend to pick quite a number of people to appoint to leadership slates. So it's not as if there have to be a monopoly on the repeat players. You could have a couple of repeat players with a lot of experience who kind of know how these particular deals work. But you could also bring in some new blood from the outside so that you have an outsider's perspective. That is key, particularly to different types of interests within the MDL. So, I would just remind everyone that the statute, the MDL statute, simply requires a common question of fact. It doesn't require that common questions predominate over individual ones in the same way that we do have in the class action context. And so you have a lot of people who are very dissimilarly situated who could be disserved if leadership only has a certain type of clients that are represented in those decision-making, around the decision-making table.
Okay, I think judges are sensitive to the importance of diversity in selecting counsel. So with that, Chris, do you want to respond to the points that Beth made before we go into any suggestions on improvements in the process?
Yeah, and look, I think Beth gets a lot of heat from people in my bar and the defense bar as well, and perhaps even some judges, because when you read the book, it feels like an unfair indictment of the people who live in this world every day and who frankly try to do a really good job. I would consider myself one of them. And this is not a criticism of you, Beth, but I feel like, my cases have been unfairly portrayed in your book, but I think that gets to something that you and I do agree on. And that is, I think that's a creature of the fact that there is a lack of transparency, and why I supported as a board member, but also just generally the project of trying to shed more light on what's going on in the MDL world, similar, but even beyond what you have in the class action world. And I think that in many cases we have done that. And in some cases, we haven't. I mean, I haven't handled all the cases that you write about, but so I would like to make a couple of comments, and you put a lot out there, and I don't know if I caught every point, but some of the problem by trying to fill the gaps by interviewing people that might have been involved and maybe they had a small role, or trying to sift through the record without really talking to the people that directly involved and at least giving them a say would be like Propulsive is a good example. And I think what's missed in Propulsive is the fact, and you referenced this in your comments, that Propulsive was brought back in, I believe, 1999, 2000. In those days, there were a number of state court venues that had their own MDLs. New Jersey, for example, has a procedure for centralizing cases before one court that are filed in that state. California has a procedure like that. Texas has a procedure like that. There was significant state court litigation in Propulsive, and it involved a heart injury, but there was a component of that heart injury that was ultimately determined to be relatively benign. I mean, this is just the way litigation plays out. Not every litigation the plaintiff brings is successful. Sometimes they're totally unsuccessful, or you're just trying to navigate through the issues. So let me just be a little more specific about Propulsive without getting into details that would violate a confidentiality agreement. But there are thousands of cases that were settled in state court, like the ones that you were talking about, Beth, involving infants. I know because I represented a number of families. I had 2 cases set for trial that settled on the eve of trial pretty much. And I can just assure you that those settlements were substantial. That the work product that many state lawyers used came from the MDL, from the lawyers in the MDL who put a lot of time and money working up that discovery and used, we in state, I was in both places, I was in the federal court and in state court, used that venue because everything was centralized there. And Judge Fallon was a judge who was on top of it and moving the case very quickly. Pretty much everybody, not totally, but sat back and used the depositions that were taken in the MDL. So to make a really long story short, the piece of the picture that's missing is the fact that, and you reference this in your book, I went back and looked, the criticism that you have of the federal program wasn't what they called back then an endgame program. It was an endgame committee put together by both sides to pretty much take the thousands of cases that were left that were not settled, and to create a program where they could fairly be reviewed and compensated if they were, worthy of compensation. The problem in Proposed is that it involved an injury called QT prolongation, which if you didn't suffer an event while your QT lines were prolonged, it has to do with your heart rhythm and your heart repolarization of your heart. If you didn't suffer an event and you got off the drug, the evidence was that you went back to normal. And there were a lot of cases, because if people remember, the way these litigations typically develop is that, a study comes out or a number of adverse events get reported, a drug gets pulled from the market, and everyone's off to the races. The scientific community, the legal community, and everybody else. And sometimes you have the science developing right alongside the litigation. And in the beginning, what you think is an injury might not be, or what you don't think is an injury may turn out to be. On the points that you make about, so my point is, my conclusion on that is I think it's unfair to judge the attorney's fees just based upon the federal program, when in fact they had negotiated to be compensated by J&J for work that was done that benefited the entire country, frankly. And it wasn't just the federal program. The other things you talk about, though, are a little more difficult to dissect. It's kind of like the analogy you hear about sausage making. Nobody really likes looking at the process, but sometimes you have to go through that to get to the result. The 85% walk away that you talk about, even in class actions, you have triggers, right? You have blow provisions. It's the same concept in an aggregate deal, non-class deal, that you have to have a certain amount of participation, because what the defendant is paying for is peace. Now, the advantage to the plaintiffs is that there is a peace premium to be paid for that. For lawyers like me and others who can negotiate those deals, get those values to a point where we believe 85, 90% of the country will, or more, will buy in, defendants are more than willing not only to pay for that, but to pay a premium for it. That benefits my clients. That is not a bad thing from a plaintiff's perspective. And defendants are willing to pay it. On the quick point, I'll try to go through these quickly, Judge. I don't want to take up too much time, but there's a lot to be said on this. You came up, I think, Beth, and I again, not a criticism of you in any way.
Could I just stop you for a moment on the walkaways?
Yeah, sure, Judge.
We'll get to it later with respect to the ethical problems that plaintiffs' lawyers deal with, but what's your experience with respect to whether deals collapse over a sufficient number of walkaways? In other contexts, I think that they're seldom met.
Yeah, in the class action world, there are instances where they're not met, and there are pretty much 2 or 3 consequences of that. Would be you renegotiate the deal and come back with another one. That typically happens. Or the defendant says, I got enough, I'm happy, we'll go forward with this. And I think that happens more often. And there are instances where the deals blow. And I had a case like that, where the deal didn't achieve the number, and the opt-outs were greater than the class action, than the defendant was willing to take the risk on, and they blew the deal. And by the way, litigation wound up never settling. In fact, I think it's still pending. It's been probably over 10 years.
Okay, so, go ahead.
Yeah, thank you. I also think one of the points I was going to make about, these provisions that people take issue with registration. So, that's really not a big requirement. In one of the instances you talk about in your book is the Zimmer hip case I did handle. And we had a requirement that everybody had to register in that case. And I think you were critical of it, but I also think based on the people that you interviewed, I think you got bad advice on that one. So let me just quickly explain what happened, and I'll do it very fast, and then explain why I think you got that one wrong. Because you made it sound like Mark Lanier and I kind of snuck around and settled the case. I was originally appointed liaison counsel by Judge Wigginton. I had a settlement on the table. A firm came along and thought, we're so much better than Seeger in this deal that we're going to go try cases and we're going to drive the values up. That was Waters and Krauss. I don't mind saying it's a fact. They lost all 5 of their trials. I don't know if anybody here has any idea of how difficult it was to get Zimmer back to the table after 5 trials were lost by the plaintiffs, but it was really a monumental undertaking. And I was frankly asked by the judge to have a little bit more involvement in that respect. So what we did is we created a voluntary program that had a couple of simple requirements. If you had a case on file, just register it. Register it. Don't settle it. Register it. And if you registered it, you had to give some information about your case. That gave Zimmer an opportunity to make you an offer. If you didn't like the offer, the case went to mediation. If you didn't like the mediation, your case went to trial. So look, again, I'm not trying to be super critical of you. I understand that these things that people don't get or know get filled in with sometimes conjecture, but totally legitimate program. And by the way, 99.9% of every plaintiff and lawyer who had plaintiffs wound up settling their cases. So that's some evidence that it was a decent settlement. And the fact that we were able, after 5 straight trial losses by a firm that came from the outside, to get it back on track at the same values, I think was a positive thing. So, you know, look, I have some other, you know, criticisms. I mean, one last one is, you know, because this is a matter of public record, that, you know, in the NFL concussion litigation, I was kind of taken to task in your book because I procured so if anybody knows anything about the NFL concussion litigation, once we secured the fund, what I believe were predatory lenders stepped in and started making loans to NFL players for basically money that they were guaranteed to get because they had a diagnosis. And these awards went up to $5 million per individual. And lenders came in and were making loans at exorbitant interest rates, and they were restyling loan agreements as purchase and sale agreements to try to get around the usury laws. I found out about that very early because the class rep in that case, Kevin Turner's family, needed a loan. They were having a hard time. Kevin had ALS and he didn't survive the approval of the settlement, unfortunately. So I went to a bank that I had a relationship with. I was actually on the board of a startup bank. And I said to the judge, we had a meeting. I said, look, there's some stuff going on out there. I'm not happy with it. I'm more than happy to resign from this non-paying position I have. I wasn't making any money. I was just an advisor. But I found a bank that will step into this space and make loans at 9% simple interest. And with everyone's approval in the case, everybody thought that was a great idea, that if a player needed to borrow money, they could take a loan at 9% simple interest. These were revolving credit lines, so if you didn't borrow from them, you didn't pay interest. And I really, I came under attack by counsel representing these predatory lenders that made horrible accusations about me, none of which was borne out. They're in an affidavit. The court was fully aware, totally apprised, understood this, actually appreciated the fact that if people were going to borrow, that I would make that lender available to lawyers so that they would know about it and put their clients in a better deal, which kind of left the court and others scratching their head about why would a lawyer put themselves in a 50 or 80% deal when you can get a loan for 9% simple interest. Other people can answer those questions, but I took a lot of heat on that. So look, my point is I support Beth on her effort for transparency. I obviously support the project undertaken here at NYU. And I don't falter for the mistakes, but I felt the need to correct some of them.
Could I just stop you there also? Beth has talked about the need for transparency. What does that mean? What sort of data is it possible to get that should be gotten, and how can it be gotten? It would seem from Beth's book that what is desirable is some understanding of how many plaintiffs benefit from the settlement of aggregate litigation, in what amounts compared to the common fund. But could you be, Chris, you say you support transparency. Could each of you be a little more specific about what you mean in terms of transparency? One would assume it takes an awful lot to try and come up with statistics. For example, settlement programs can drag on for years and you don't know the ultimate value until the end of the whole process.
That is true. But I do think, I actually agree with Beth on this one. You know, But you don't really see this much in the MDL world, like, you know, so it was more of an issue in the class action world where consumer cases were brought, whatever was given out, the class would claim $1 million or $2 million, and the lawyers got a fee that was a multiple of that. And there's been a lot of criticism of those. And I do think judges now watch those numbers more closely for that reason, and rightfully so, I believe. I'll probably get criticized by a lot of people, but I believe. I do also support the deterrent effect of class action, so maybe there needs to be a balance in there. But on the MDL side, the money gets spent. I'm also, and I'd love to hear from Beth on this, I'm a little confused by that because in Vioxx, where we negotiated $4.85 billion, and there was a standardized grid or matrix that said where you plotted out, every nickel was spent, and we did do monthly reports because Judge Fallon required them. Very similar to a class action where the claim administrator came in, we did monthly reporting, we tracked how the dollars went out, who they got paid to, and those things. So I think the mass tort world is doing a much better job. I think where we're not doing a great job is getting that data centralized in a form where people can study it and look, people like Beth can study it and look at it and satisfy themselves. But you know, because some courts publish it and some courts don't. But that information is available. And in the mass tort world, you don't really have the issue of holding attorneys' feet to the fire because what the amounts that get negotiated do get spent. I mean, that's just generally speaking. I'm sure you can find an example maybe, but if we're going to demonstrate our points by the one bad example out there, then we won't get very far. Most do a good job.
Well, so I would just add a couple of things there. You know, I think a lot of it depends on the way the settlement comes down. So, you know, one of the things that I don't think we talked about at the beginning was the different types of settlements. So, you know, even in a class action settlement, when I look at the dockets, typically judges' involvement ends after they approve the fairness of the settlement. Now, that's certainly not true in something like the NFL concussion case, but in a lot of these types of settlements, the judge is sort of done as soon as the deal is approved, which means that the claims administrative, sort of the forms can be very difficult. There can be a whole lot of jumps that you have to go through in order to actually get the money that you're seeking. And so, you know, one of the things that the Rules Committee has been trying to consider is how can we get data on the amount of money that people are actually getting under types of class actions. And I know Brian Fitzpatrick has done a little bit of work in this area in some of the smaller consumer claims classes. So that's kind of one piece of the puzzle. The other piece of the puzzle is a global deal where you have a claims administrator who is kind of at the head of the pyramid, maybe even a special master who is over the claims administrator and who hears these sort of quasi appeals within the class settlement, within the non-class settlement. But then there are also these inventory deals, which I think are becoming quite prevalent, particularly in the pelvic mesh litigations, where it's really dependent on the type of firm. And so it's really hard, I think, to be able, if you're a pelvic mesh plaintiff, to say, well, I got X amount. I have no idea how much somebody who was similarly situated to me got. Is that fair? And so, you know, I think one of the things that Peter and David are struggling with, and maybe they could talk a little bit more about this if they're inclined, but there's all these different data points that claims administrators collect. And so when you say you need data, the question is, you know, well, what kind of data? And are we looking at an apples to apples comparison, or are we really looking at something that's apples to oranges? And how can we kind of measure it and put it into a form which is something which gives you something to work with? And I noticed that Joe Cecil and Margie Williams are both on here, so they might be able to chime in terms of the Federal Judicial Center and kind of what's needed to help collect some of that data.
As an aside, I don't think it's completely true that judges are out of the process once they've approved the settlement in a class action, because the settlement will usually include what happens to the residual fund if in fact it's not distributed. And if there's enough, it usually gets distributed to the plaintiff class. And if there isn't enough, it goes to some CPRE organization. But the court will still have to approve that under the usual terms of a settlement, which may well not be true in the aggregate context, particularly when these distributions go on for years. So it is difficult to know what the data is that really is necessary to help get more transparency. Chris?
Judge, I strongly agree with what you just said. In fact, when Beth was speaking, I was thinking to myself, it would be great if somebody, look, I know the project that NYU has undertaken to collect that data. That is difficult because you got to go through attorneys, there's confidentiality agreements, judges are involved, and then finally claim administrators that might not be willing to release information about cases. I get that. But if I'm leading a case, or other people on this conference who lead cases know that, okay, I think that people would find this kind of data interesting. We could probably build that into some kind of a monthly report that gets filed with the court. I mean, I've attempted to do this, frankly, in every case. In some cases, maybe I've done it better than others. I think I'm getting better at it. So there is some value to repeat players, Beth, because we get experience as we get older and get better at some of these things. But I guess the question is, what are you not seeing that would be helpful? I mean, because it's pretty common since Vioxx, even in non-class deals, to at least report number of claims that have come in, claims that have been rejected, claims that have been paid in various categories. And ultimately, you can see and trace the money going out. Now, the part that maybe you would have some concern about, and I wouldn't disagree with it, is what happens after the money leaves the fund. And that is an issue, as you guys may know, in the NFL concussion litigation. That very issue wound up going up to the Third Circuit in the context of these predatory lenders, where Judge Brody invalidated their assignments because we had a provision in the agreement against them. But that was one of the questions the Third Circuit looked at. Is at what point does your authority as an MDL judge, like how far out can you follow the money? And pretty much what the Third Circuit said is when it leaves the claim administrator's hands, you're pretty much done at that point. And go ahead, Judge.
I've been asked to make an announcement for purposes of CLE purposes. So the first CLE code is CCJ MDL 1. Please write that down because you'll need it in filling out the CLE form we will send you. Again, the first code is CCJ MDL 1. Sorry to interrupt you, Chris. Go ahead.
No problem at all. The point I was just kind of going to conclude on was, there is some concern from some judges who have raised this with me in cases I've been involved with. Is like, well, what do you know about the money once it leaves? For example, where a judge might say, I'm going to reduce the contingent fee contracts from 40% in some jurisdictions to 30%. How do I know that's being enforced? That's where you start getting into a little bit more complicated situation. Judges may ask, how do I know that the expenses are being properly accounted for? Now, the answer, which might not be satisfactory, is most lawyers have an accounting obligation in every state under their rules of practice that a client has to get an accounting sheet. But look, my point is simply there's a lot that could be monitored, and but I guess I would need to, as a leader in these cases, get a better understanding of what it is that people are most interested in your world. Beth.
I think who gets what and why is really central, and I don't think it's as obvious as maybe it is to you. I've looked at a lot of these dockets and looked at a lot of these different hearing transcripts, and it's really hard to try to find any data, particularly in non-class deals, about who gets what and why, and whether like plaintiffs are being treated similarly, which in some ways raises kind of the ethics points that I know we were going to get to. And the big question, of course, being, is it okay for lead lawyers to strike better deals for their inventory of clients than for everybody else who's in the MDL?
We can get to the ethics question in just a moment. We got a question which is, I think, related from the audience to what we've been talking about. Two of the questions. One is for either of you, do you know what percentage of the MDL cases are decided on the merits, whether it be summary judgment for the plaintiffs or dismissals in favor of the defendant?
So there are different percentages depending on kind of how you're looking and what data set you're looking at. In terms of defense wins, it's between 9 and 14% at different samples that I've looked at. So, you know, dispositive wins, whether that's an arbitration or a Daubert motion, something like that.
And another question for Beth. If the medical experts found that so few claims in Propulsid were actually meritorious, isn't that an indication that the litigation may well not have been meritorious?
So I think that's certainly possible. You know, I'm not as familiar with the ins and outs of the litigation, but if that is the case, then there's still the very real question of why did the lead plaintiff's lawyers get paid $27 million to bring non-meritorious claims?
No, that's not why they were paid. They were paid. So I'm going to just try to break this out really simply. Propulsion involved what everyone thought were two injuries when it started. One was the prolongation of this QT wave. The other one was sudden death. Sudden cardiac death. I represented families that lost 3-month-old infants and a little bit older. So, you know, I know this issue still, even though it's been over 20 years. What happened in the litigation is that if you suffered an event, a cardiac event, while your QT wave was prolonged, that was a compensable case. But I don't think any judge ruled that the mere prolongation of those waves without something else, and the fact that once you got off the drug, they resolved. I'm not aware of any judge in the country ruling that that was a Daubert-worthy injury that could go to a jury. And that's a very, very important detail here, because it just turned out that was one of those litigations where, let's say there were 10,000 claims, maybe 500 to 1,000 were compensable because there were death claims or they had a cardiac event which landed them in the hospital. So, you know, I mean, that's why digging into the details really matters in these cases. And it ultimately comes down to, you know, what's available, I guess, for people to dig into, which is.
So, I mean, if we're talking about digging into cases, I mean, is there any problem with tying the lead plaintiff's lawyers' common benefit fees to the plaintiff's outcome rather than allowing them to bargain with the defendants to increase those fees?
No, but I don't know why the bargaining with the defendants is giving you such, you know, heartburn, because that happens in a lot of cases and most people view that as a positive. No, I know you're smiling, but most people view that as a positive because those are fees that courts take into consideration that don't come from consumers or injured plaintiffs. So, and remember, you know, in that one case that you pick on and you like, the Propulsion case, yes, they came from the defendant. Most of the time, that's not how it happens.
Now, 84% of the time, there is some aspect of common benefit fees, at least in the settlements that I was able to look at, where they're.
But you've confused two important things. You're confused on this one point. Getting money from the defendant is one issue. Put that to the side. What typically happens is a court enters an order in these mass tort cases, non-class cases, that says they create a holdback. So if a case settles for $100 and there's a 10% holdback, $10 get held back. But that money does not come from the client. It comes from the individual attorney representing that. It is a redistribution of attorney's fees from lawyers who have done virtually no work to a committee of lawyers that did all the work. So in the Vioxx litigation, we tried 18 plaintiffs. That's a massive undertaking. Judge Koeltl will, I'm sure, say this. You don't see trials that often. I can tell you in the mass tort world, we try cases all the time in these injury cases. And we're doing that for the benefit of lawyers who did nothing but advertise and sit on their cases. So courts have found it fair to redistribute attorney's fees away from them into a committee who did the work.
Well, but that aligns with this whole common benefit fee theory, right? If you're basing your common benefit fees on quantum merit, then there should be no reason in, say, Vioxx, where you start out with a 3% common benefit fee that Judge Fallon has ordered, and then you negotiate with the defense for an 8% common benefit fee, and then it gets cut by Judge Fallon back down to 6.5%.
No,
But that
that's not
cut
happening.
back down to 6.5% doesn't always occur.
No,
And that's more than
that's
double.
not what happened.
Well, hold on, one at a time.
What happened in Vioxx, just to
Chris's,
clear that up. We negotiated that the defendants would not object to a fee that we would sink up to a certain amount. We did go back to Judge Fallon and said, the committee has spent $41 million in cash litigating this case, and we have 1 million hours. Judge, we think that the 3% holdback is not fair in light of the fact that this case went on for many years. We achieved almost a $5 billion result, and we spent all this money. And Judge Fallon, so we asked the defendant not to object to an application that would go up to that amount. Judge Fallon looked at it and he reduced it. He didn't award the 8%, he awarded 6.5. He increased it from 3, but he awarded 6.5, less than we asked the defendant not to object to. So that's really very different. We're not negotiating fees with defendants. You're misunderstanding what happened there.
but go ahead, Beth.
Well,
Go ahead.
Say, it sounds to me like the arguments that you're making are the same sort of arguments that you would make under a quantum merit theory, right? Which is that we've benefited a whole bunch of people in ways that we are not being compensated for. Therefore, we should get a higher fee. So I don't know that we're really disagreeing on the substance here.
No, maybe not. I mean, I'm not sure I agree with you with the way you're defining it. Suggested you're defining quantum merit, because it's obvious that plaintiff's attorneys in successful litigation, seek to be. We have a lot of losses and we have a lot of wins. We stay in business with the cases that win, where courts see fit to pay us, either our hourly rate or a multiple of that even. So I'm not sure what you mean by quantum merit. But I think you're right. I think we are not totally disagreeing on the concept.
But we got into this in part over a discussion of the ethical issues that face plaintiffs' lawyers in aggregate litigation. And Chris said he wanted to talk about that. So I'll pass it on to him with a couple of specific questions. Do you feel conflicted at all having numerous clients, some of whom want to go to trial, some of whom want the benefits that they can get from a monetary settlement, some who simply want to go to trial to air their claims in public, to punish, if you will, a defendant for having manufactured a product that hurt the plaintiff or the plaintiff's family. And you then face questions such as, should this individual plaintiff be required to settle the case as part of the whole group? Because that if this plaintiff doesn't agree to the settlement, you can't continue to represent that plaintiff, or you won't continue to represent that plaintiff, and the plaintiff may not be able to get any other lawyer. So could you talk to us a bit about the ethical problems that, as a plaintiff's lawyer, you face in these litigations?
Yeah, so frankly, I have never had major problems, explaining to my clients, whether it was a single client or more, what the pluses and minuses were to accepting a settlement versus going to trial. There's nothing about the mass tort world that changes or should change that relationship and that dialogue. What happens, though, is many times these provisions that call into question ethics are requested by defendants for certain reasons. So in the Vioxx litigation, Merck's fear was that lawyers would settle, they would take this $4.85 billion pot, opt out 100 very strong cases and go try those throughout the country. And then, Merck would then pay, in effect, almost $5 billion plus some big number. And what they said was, if you're going to be involved in this settlement, and at the end of the day, you have a client that won't accept it, you don't have to discontinue. That person doesn't have to waive their claim. But the provision they wanted was that the attorney representing them had to basically release their attorney fee lien on that claim so that person could go get another lawyer. Now, there's a lot packed into that, more than just the way I framed it. One is, how many times that even came up, I don't know. It wasn't that much, I can tell you. In many cases, lawyers did not have to actually withdraw because we put a provision in the agreement. So Merck's concern was this cherry picking concern. We put a provision in the agreement that if the attorney wanted to continue representing that client, they had to go to Judge Fallon, and Judge Fallon had to satisfy himself that what was going on was legitimate. And in fact, many attorneys continued to represent their clients outside of the settlement. So, but the issue, the other factor that really gets missed is that the reason the attorneys had to waive their fee is so that that person, if that lawyer couldn't keep representing them, could go get another lawyer and start from scratch, because they had two big advantages. One was 18 trials. So there was a mature trial package that could be put on a hard drive and handed to any lawyer that decided he wanted to go forward with that plaintiff's claim, if they wanted to pursue it. And the fact that they were waiving their fee was seen as a plus at the end of the day, because again, that client can now go get another lawyer at a 1/3 referral, and that lawyer could be compensated and the case wouldn't be encumbered by attorney's liens. So we were trying to solve a pretty complicated problem because, and something, Beth notes in her book, there are not a lot of rules other than ethical rules and things like that people have to adhere to, but there aren't a lot of rules about how to do these things. And sometimes you're trying to navigate that defendant's or that defense lawyer's last disaster. And those get carried into the settlement, and you're still trying to, at the same time, get a substantial amount of money to compensate plaintiffs who've been injured. But there's nobody that was either forced. I mean, I really strongly disagree with Beth on her comments about Judge Fallon wanting settlements badly. Trust me, I've had 3 major MDLs for Judge Fallon. He doesn't care if you want to settle your case or not. You can try it, or you can settle it, or he'll remand it. He makes that clear to everybody. So number one, that's not true. I don't know, I don't remember the quote in the book, but I never heard Judge Fallon put pressure on a plaintiff to settle a case. And frankly, these issues all wound up working themselves out, because when Vioxx was announced, we got called before certain ethic boards in certain states, and we had to explain the settlement to them, and not one pressed an ethical issue against us. Not one ethics committee that we appeared in front of, once we explained the settlement, including there were law journals that we had to go meet with their editorial boards. And once we worked them through the settlement, nobody claimed that we did anything unethical, and I'm convinced we didn't, or I wouldn't have done the deal. So,
what do you do with clients who maybe you've just never had them, who simply don't want the settlement, who want to go to trial?
I mean, it's rare, but there's another. It's rare that happens. It has happened. And, if your client just wants to go to trial, you hope that they will listen to you if you think that case shouldn't go to trial for certain reasons. Like maybe it's not that strong, or there could be other things. That's a lawyer's job in any litigation, to advise their client on what they think is best. But you do from time to time have people that want to just push it. And what happens is the case either gets tried or it gets dismissed before trial. And that has happened.
But don't you have an obligation under some of the agreements to withdraw from representing the client?
Well, certain agreements, like I said, in the Vioxx deal, in the settlement, yes, you had that obligation if the client didn't accept the deal. But like I said, once those cases were looked at and the parties and the judge were satisfied that there was no gamesmanship or an attempt to cherry pick a case out and go try it somewhere else, that there were legitimate reasons that client didn't want the settlement, they were allowed to continue with their case. Now, it turns out that, we're kind of talking about something that really, it just really didn't come in. It was not 99.9% of everybody that was eligible to take the settlement did.
A final question. When you are a lead lawyer in one of these non-class action cases in an MDL, what do you think your responsibilities are to the clients whom you are not actually representing in that group?
So that is a question that we deal with every time a committee is formed. It's what claims are we going to be able to prosecute? There are all kinds of, you get a sense after a certain amount of time what the litigation is really about. Using Vioxx as the example, it became clear to everybody that what the real injury was in Vioxx was a heart attack. That's what Vioxx was implicated in increasing the risk. But there were other people that wanted to bring other kinds of claims. There were claims for bone damage, wound healing, but I'm not aware of any court in the land where any of those claims made it through Daubert. So, and there are times where the committee that I'll lead or be a part of has to make a decision that we're going to only prosecute these claims because based on the work we've done with our experts, we don't think these other claims have a chance of success for whatever reason. And we usually will get letters and communicate that to the plaintiff's party. That doesn't mean the claim is over. That just means the committee won't prosecute that claim. But individual lawyers, if they believe in that claim, can go ahead and prosecute it. And some did. And some have in other cases. But I think we do a very good job as a committee working with the best experts in the country of identifying what the injuries are that should be prosecuted and litigated. And that could get through a Daubert screening and get to a jury.
Yes. Go ahead.
Judge, I didn't mean to interrupt you.
No.
Couldn't that also be a good opportunity to have, we sort of mentioned in passing this possibility of episodic remands. This is something before he died, Professor Francis McGovern interviewed a whole bunch of lawyers across the country, I think 90 different attorneys who are involved in these MDLs. And one of the things that they brought up over and over again was, and I'm quoting here, many lawyers, quote, simply want out and want a way to express their frustration without alienating the judge. And so, I think if the leadership is not working up a whole bunch of different types of injuries, that's a really good point at which to remand the cases that aren't being worked up so that they don't just sort of stagnate in the MDL and they do have an opportunity to work on their cases before someone else in front of a different judge. There's other opportunities for remands, and I think that there's some good possibilities for them. I think they build in judicial redundancy. They give plaintiffs an opportunity to have some control over their proceedings. It can relieve some of the burdens that I think MDL faces with generating and aggregating a whole bunch of state law claims that get watered down in terms of an MDL settlement. So, I think having more episodic remands occurring with greater frequently, as opposed to this sort of stigma that I think is hopefully changing among MDL judges, that remand is failure. Judge Rubino has written about this in the past, but continuing to remand cases and giving plaintiffs attorneys an opportunity to work up their own cases, I think can be really important.
Chris?
Yeah, so I've observed over, 25 years of doing these interesting dynamic, the remand issue kind of comes in waves. My experience with and I don't disagree with what Beth said. I don't have a problem with judges remanding, but my experience with this has been judges who mention, I've gone as far as I can go here. We've worked this case up. You've tried one or two. Okay, you're either going to use the efficiencies here of the MDL and settle, or I'm going to remand the cases. And in my experience, this doesn't mean it happens all the time. Many defendants go, whoa, judge, hold on. We don't want you remanding 30,000 cases throughout the country. But I've seen a shift lately from defense firms suggesting to judges they feel like trials put too much pressure on them, and they've been pushing MDL judges here and there to go ahead and remand cases. So, look, I think the remand issue is something that every judge has to look at. The episodic remand problem, I don't disagree with episodic remands. I guess the question is, in what series or what bunches are you going to remand? In the case with Francis in the opioid litigation, Francis had a plan that he wanted to implement that he thought remanding some but not all made some sense. Some defendants may not like that. They may take an all or nothing approach. So I do think that when an MDL is created, you have to give it an opportunity to succeed in what it's designed to do, which is to create those efficiencies for the parties. But I also agree that at some point, There are some judges that are more patient than others and will continue to try cases until the parties see the light, but and settle. Or I've seen them say and which has become more common, we'll try a few here, see if you can generate the data you need to inform your discussions on settlement. But if you can't settle, don't worry. We'll at some point I'll either bring in more judges from the district and we'll try more, or I'll start to remand cases throughout the country. So that's just what I've seen. Not sure if it helps Beth's point that much, but I don't have anything against.
No, I think you both sort of agree on episodic remands. The problem I would think is that defendants would fight it and explain that there's more to be done in the MDL and that the judge should do what the judge was appointed to do, namely to finish all of the pretrial proceedings. And before the MDL is done, there's probably some resistance to starting the remands. But I mean, you both agree episodic remands can be very useful.
Yes,
so
absolutely.
Is there any data on the number of what you've described as episodic remands?
So historically, it's less than 3%. Less than 3% of the cases that are ever centralized through an MDL are ever returned to their original districts. And I think Judge Rubino remanded a number of cases in the asbestos litigation. There are remands that occur at the end of almost every proceeding. And I think the experiment that Chris was talking about in front of Judge Polster has designed this sort of hub and spoke model where a number of cases have been remanded that are being tried in West Virginia and San Francisco and Oklahoma. Maybe I'm leaving some out. And so that, not everything is supervised by the same judge. And, I think that's a really good idea, that it builds some judicial redundancy into the process, that the pressure isn't on one single judge to decide all of these issues, particularly issues that very rarely get any sort of audience in front of courts of appeals.
Which brings us to another observation in your book. My sense was, to put it gently, you think that MDL judges should be doing a better job, that the judges may be part of the problem. So in keeping with the themes of improvements, other than building better judges, what do you think should be done?
Well, I'll give you some statistics. I'll share this this PowerPoint here really quickly, just so you have some data and have a sense as to what I'm talking about. Again, I'm looking at what judges are doing in the 34 proceedings that ended in these private aggregate settlements. And I think one conclusion that you could take away from some of my earlier comments is that we need more judicial involvement and more judicial oversight, particularly when we have these very complex issues and complex settlements, and the plaintiffs may not always have a good attorney-client relationship. So I started looking to see what judges are actually doing. And I found that judges are already nudging the plaintiffs. So to varying degrees, in 53% of the non-class proceedings, federal judges approved these private settlements. These were not class actions, which of course sort of blurs conventional wisdom that suggests that private settlements are in fact private. Now, what we're hoping is that judges are going to be sending the plaintiffs reliable information that the deals are good deals or bad deals. But of course, unless the judge has had an opportunity to really rule on the merits through the adversarial process, then that can be a very tough position for judges to be in. And so what I found is that before they ruled on these types of deals, within the data set, that almost a third of them hadn't also ruled on any sort of merits related motion, nor had they presided over bellwether trials. but they judicially stayed the private settlements deadlines. They issued these census orders, and they stayed the proceedings, which meant that plaintiffs that didn't want to settle had their cases sort of put on ice, so to speak, while the settlement proceeded. Now, there were other judges that made extensive rulings on the merits, but kind of left plaintiffs with very little choice about whether to enter into a settlement agreement. And so there are different ways that these kinds of nudges can occur. And I think collectively, what I worry about is that there are increasing numbers of burdens that are put on the plaintiffs themselves. And I think it's not readily acknowledged, particularly when a judge is faced with this kind of crushing burden of cases. So 64.7% appointed claims administrators or settlement masters. And so in the eyes of plaintiffs, a lot of them think that that means that the judge is actually formally approving the deal, even though these are private settlements and they're not going through Rule 23E's checks for whether they're fair, reasonable, or adequate. 35% had all of the attorneys register their clients, whether they were in state court or in federal court, essentially kind of stretching jurisdictional boundaries to get information about plaintiffs who are not before them. 35%, and again, this is all of the private aggregate settlements, not just the settlements that I could actually look at. So 35% allowed attorneys to withdraw from representing clients who didn't want to enter into the settlement agreement. 67% of judges issued lone pine orders, and I suspect most of our participants know what lone pine orders are, but for those that don't, sometimes they impose evidentiary burdens with a relatively short deadline attached to them. So for example, you have a month to get a case-specific expert and a generic causation expert. Otherwise, your case will actually be dismissed. And the implication, of course, is you can either enter into the settlement agreement or you can kind of put up your lone pine expert. Only 8% of the judges didn't take any steps of those like that whatsoever. And so I guess, my question is, what sort of authority do judges have to preside over private deals? What sort of authority do they have to say that this is a good deal or a bad deal? And I couldn't figure out what those might be. Sorry, we're kind of going backwards here. But one possibility would be legislative authorization. So it could be that the MDL subcommittee gets involved. There's a proposal that the committee is considering right now about whether to have more judicial involvement over these private settlements. The second possibility is consent, but there's no consent here because the plaintiffs haven't consented to a settlement. Instead, it seems like the judges are trying to nudge them into a settlement program. And then there's the possibility that you could use a court's inherent authority. But it turns out that there's not a lot of recent cases about what it means to have inherent authority. The last time the Supreme Court talked about inherent authority was many years ago. But what the Supreme Court said, at least in the concurrence, is that that courts can use their inherent authority only to permit courts to function. It should be used sparingly. It's not this kind of umbrella provision that a lot of judges have been using it for. And so I'll stop the screen share here. But I guess, from my perspective, I hope that judges will nudge the lead plaintiffs' lawyers, not the plaintiffs. And one way that they can do that is tie common benefit fees to the actual outcomes that plaintiffs' lead lawyers generate for the plaintiffs themselves. And so that's an easy kind of market solution that will make sure that there is this kind of monitoring that goes on. It also gives judges an opportunity through the back door to have kind of a limited glimpse into what the plaintiffs are actually receiving through these private settlement agreements.
When you say that you would hope that the judges would nudge the plaintiffs' lawyers to do what?
Well, nudge plaintiffs' lawyer. So instead of nudging the plaintiffs to enter into the settlement themselves, the nudge occurs with the plaintiffs' lawyers, because if you're the ones that are awarding the plaintiffs' lawyers their common benefit fees, then tailoring those common benefit fees rather than just having kind of a flat fee, say 7% for everybody. You could look at, one particular proceeding where an attorney has 25 cases in the federal MDL and 4,000 cases in a state court, and those 4,000 cases are taxed the same amount as the 25 cases in the MDL because of these participation agreements.
But I had a sense from your book that you were not a fan of judges urging settlements. And so when you say that the judge should be nudging plaintiffs' lawyers, my question is, nudging plaintiffs' lawyers to do what? To settle? That seems not to be consistent with your thought that judges shouldn't be the ones to be nudging settlement. Judges should be saying, hey, I'm here. I'm willing to try your case. You want to settle? Go settle. You don't settle? Welcome to trial.
Yes, that's absolutely correct. I didn't mean to be misleading in that sense. No, I don't think judges should be the ones that push plaintiffs' lawyers into settlements or defendants into settlements. I mean, if they want to settle along the way, then that's totally fine. But it worries me that settlement has become the end goal rather than trial. I think if judges are focused on the sort of traditional path to trial, that settlements will occur along the way. But if judges are wholly settlement focused, then that becomes the end game, and the litigation sort of proceeds at pace. And it ends up that you may not have as many merits related motions that are focused on sort of airing the good claims from the bad claims, so to speak.
Just one minor observation on your statistics. I'm not sure that it's reasonable to add settlement masters and claims administrators in the same category, because I would have thought that settlement masters are there to attempt to achieve a settlement, and the claims administrators are there to administer the settlement after it's been obtained. So aggregating them to show that there's 64% or 64.7% from both of those groups is mixing, I think, apples and oranges, isn't it?
So we actually have a new paper about this that's posted on SSRN. It's not out just yet. That gives a little bit more data and kind of a finer tuned look at special masters and settlement masters and claims administrators. But typically, a lot of times what will happen is that the special master will then become the settlement master. So they sort of play this dual role in the sense that they help negotiate the settlement, but then they are the ones that hear the final claims appeals from the claims administrator. And so that's the reason that they all sort of fall under the same umbrella, is that when special masters become kind of the top of the pyramid and hear appeals from claims administration, they're very much playing that function.
Chris, do you want to weigh in on your thoughts about the MDL judges?
Yeah, the problem with, I'll make a comment generally about the judges, but the problem with some of Beth's proposals is that in that world, there would never be a settlement. I mean, if every case were to go to trial, let me tell you something that I say often, okay, as somebody who considers themselves, somebody who's involved in workouts, and that's what these big cases are. When a company has tens of thousands of cases, it's a workout for both sides at some point. But there is only one road. There's one path to everybody recovering, and that's through a global settlement. The other path, the alternative, which is fine, if you were representing clients and you wanted to take it, it'd be fine, is the trial path. Now, I don't know how fast judges in this country can try 100 or 10 or 20,000 cases. If every one of them were to go to trial, my sense is the system might collapse under that weight. But let's assume you could even do it, which you can't. I would tell you, as somebody who's probably tried with my partner Dave Buchanan 24 bellwether cases, we don't win them all. In Vioxx, we won 1/3 of them. We lost 2/3. So we win some and we lose some. So the people who tried the cases and lost, what about them, I guess is my question. If you have a defendant willing to work out the problem by paying a sufficient amount of money to compensate everybody with a legitimate claim, I think that's the path that the parties have an obligation to pursue. But, and I get your point about trials, and maybe what your point is that there should be at least a few trials. And I know that cases settle without trials. I generally view those as a pretty big success if you can put together a, I don't start from the assumption that anybody selling out anybody. I come from the assumption that there are really good defense lawyers, there are really good plaintiffs lawyers that handle these, and there are very sophisticated judges, and they typically get to a pretty good result. Look, my point on the judges is that all judges are different. Some judges nudge, some judges don't. Rule 16 gives judges a lot of authority to do a lot of things, and to encourage settlements, to take cases to trial. Some judges do it more than others. Some judges have said to me in many big cases, I do not want to be involved in settlement. You guys want to talk? I'll keep setting cases for trial. You try them. And when you've had enough, let me know. But, and then some of us have had great experiences, like when I had the Zyprexa case in front of Judge Jack Weinstein. And, he's a very involved judge and was the first judge to coin the phrase of quasi-class action. Because in that case, I think the defendant was interested in inventory settlements, but it involved a drug. It was an antipsychotic drug. And some of us on the plaintiffs committee didn't think that was a good idea. So we thought that this should be in front of the court and somehow create some kind of a standardized process. Judge Weinstein brought in Ken Feinberg to administer the settlement and to distribute the money. It was one of his earlier ones. And he wrote an opinion giving him the authority to do that. And he called what we had was a quasi-class. And I'm pretty convinced if anybody goes and reads his opinion, that term is now being used today, but it's typically judges who want to assert authority in a non-class deal over attorney's fees. But when Judge Weinstein looked at that early on, I think he was going to treat it almost for all intents and purposes like it was a Rule 23 settlement. He even passed on the fairness of the settlement. So look, judges are different, and I don't think we should stifle ingenuity and creativity by judges or lawyers, frankly. And I think, I think, and I don't mean this to sound so harsh, but I think some of the unfair criticisms that get picked up by people with agendas tend to do that. Like I've been criticized for saying things like, "Oh, I'm happy there are no rules." I never said that, really. I think the point I was trying to make, that's in your book, Beth. The point I was trying to make was that I love the creativity of what we all get to do in this business, whether it's procedural rules or substantive rules or rules that don't quite fit the problem, which those of us who live in the mass tort world or in the class action world are often confronted with. Typically, what gets us all through it are judges and lawyers on both sides working through these problems and thinking long and hard about them and trying to do a good job. So I don't want to stifle that with a lot of rules.
This is a good time for me to make a CLE announcement. So the CLE code for this portion of the program is CCJMDL2. You can figure out what those initials stand for, but they are CCJMDL2. So you'll need those. You'll need that code to put on your CLE form. This is a convenient time also just to make a couple of comments about trials today in the era of COVID. Plainly, some people want to go to trial, and there are bellwether trials out there in the mass tort context. But it's hard to get cases to go to trial. Defendants want to settle bad cases. Plaintiffs want to settle weak cases. Nationwide, the last statistics that I saw were that only about 1% of all civil cases that are brought in federal court ever go to trial. There is a common myth that judges really don't want to go to trial. So judges force settlements because they really don't want to go to trial. That, I think, is a myth. I can't believe that what judges really want to do is to sit in their chambers and decide motions for summary judgment or decide Daubert motions rather than have the interest of going to trial. One of the problems of COVID is that it keeps us away from the kind of interaction that makes it a joy to be a district court judge, a trial judge. A couple of comments about how we're dealing with COVID and trials in this district. I think we were probably the first court to start jury trials despite COVID. We started them either early this month or last month. We're doing primarily criminal cases with civil cases as backup, but there are civil cases now going to trial. We've had to reconfigure our courtrooms, so we have several large courtrooms where the jury boxes have been expanded. Jury selection goes on in a huge room downstairs that was the jury assembly room, is now the jury selection room, so that all of the potential jurors are socially spaced, with an overflow courtroom also socially spaced with video. The courtrooms have plexiglass and ventilation systems for the witness and for the podium. The microphones all have covers which are changed. We are extremely sensitive about keeping people socially distant. So every other bench can't be used, and we have places where people can sit. One of the offshoots of this is that we do a jury questionnaire for the potential jurors, where they have to explain whether they've had any COVID symptoms or come from a place with high COVID, and other questions like that, and other questions which essentially ask jurors if there are any features such as home care or the like that would make them want to postpone jury service or be excused from jury service, so that the pool of jurors who actually come down to the courthouse is somewhat screened from the people who would otherwise begin to make objections to service. So I've been told that the jury selection process has actually gone more quickly, and that some people who have been excused from jury service regretted the fact that they weren't actually picked to sit on juries. But it's plain that we are a ways away from having the capacity to do the numbers of trials that we did before COVID, and there's no good way of telling when we'll all be back. So I salute all of you who are involved in the process. There was, I want to give Peter some time to talk about data collection, but before I do, there was one other topic we wanted to touch on, which was a negotiation class action, which Chris isn't involved in. So do you want to give us a few minutes on that, Chris?
Yeah, and I'll keep it very brief, Judge, because we just filed a petition for an en banc, and I don't really know if I want to comment much on the intricacies of it, but I will say, Beth had mentioned earlier Professor Francis McGovern, who I believe you all, probably everybody knows and knew Francis, who passed away recently. Francis was the special master in that case, and he and Bill Rubenstein came up with an idea that they thought would help solve a problem that we were having in that case. And it was this, it's such opioid litigation, is such a massive case, 33,000 separate political subdivisions, over 2,000 actually brought claims. And one of the questions that we were constantly confronted with by defendants was, there are a lot of political subdivisions out there that we don't know if you guys speak for them. So why are we even talking to you? And it was just an impediment to really trying to get discussions going. So they came up with the concept of the negotiation class. And it was based on the ALI project that folks may be familiar with and may not. But the idea is this in the negotiation class, that a class for negotiation purposes would be certified. It's not certified for litigation purposes or for settlement purposes. It would simply be certified for the purposes of unifying a group of plaintiffs, putting them together in a group. And then once a settlement was achieved, so that they could speak with one voice. And then once a settlement was achieved, there was a voting mechanism where a supermajority had to approve the settlement. And if they did, the settlement would go forward and then be submitted to the court under 23E as a settlement class. So the district court judge, Polster, certified that. And look, let me just say another couple things about it sounds like a scary thing. And for people sitting out there who may not know it, it really isn't, because all it did is unify the class for the purposes of negotiating. It did not have to be used. It was a totally voluntary mechanism. So if a defendant said, not interested in a class action settlement, we want to do a Vioxx-like settlement, you did not have to, they were not bound. They were not bound to use this mechanism. It was one more tool on the shelf that we could use to get something settled. Totally voluntary, and all parties had to agree to it. Judge Polster approved it. Sixth Circuit threw it out, saying it wasn't sufficiently tethered to Rule 23. And we petitioned for en banc because we disagree with that for reasons I won't go into. But just one simple point that, for a long time, settlement classes were not really specifically authorized under Rule 23 until the amendments. And judges and parties have extended Rule 23 over time, and we think it should have been here. But having said that, that's probably about as far as I'll go on the negotiating class, unless anybody has a specific question. But I thought it was a fascinating option to have out there in case it was ever useful.
Beth, did you want to have any closing remark?
Well, I know Peter and David wanted to take a few minutes to talk about their project on data collection. I would just close with this idea that we absolutely need more transparency in these cases on the back end and on the front end. In a lot of the cases, it's really difficult to even get information about the attorney's fees and the common benefit fees. A number of those have even been sealed by the judges. So I think, first getting more transparency and then thinking about how you build in guardrails for some of the biggest cases in our nation.
Could I make a quick closing point, Judge?
Yes, sure.
And I just want to say this, and I again, Beth and I have a number of disagreements, but I do respect her in what she does. I think that her ultimate goal of shining a light on things that aren't apparent to people is noble. But she has triggered other scholars like her to look at this issue. So I just wanted to put out there, and maybe I can send the link to David, but there was an article written relatively recently by two academics who Beth knows well, and I know, Andrew Bratt and Ted Rave. Was published in the Georgetown Law Journal. And the title is, "It's Good to Have the Haves on Your Side, a Defense of Repeat Players in Multi-District Litigation." And they conclude in the abstract portion with saying, "We urge policymakers and scholars not to lose sight of the significant benefits to plaintiffs of having repeat players on their side." And the conclusion basically is that repeat players have access to things and information and expertise that will ultimately benefit their clients. I'm not sure Beth says, I don't think Beth is really, I think somehow
those same things in the article that I wrote, so it's okay.
No, and I'm not citing this as a disagreement or in any way to say I think you've triggered a lot of this stuff, but it's good for people to know that there is this other paper that picks up on some of the things you threw out there. So.
Well, it's been a pleasure for me to engage in the discussion with both of you. So thank you. And I'll turn it over to Peter now.
Judge, Arthur would be very proud of the job you did today. Arthur would be very proud.
Arthur is always with us.
Right, always.
So even more important than talking about the data project is my wanting to say thank you to all three of you. This was really a terrific. You guys did a fabulous job, and I think I know a fair amount about aggregate litigation. maybe not as much as Elizabeth, or maybe not as much as any of the three panelists, but a fair amount. And every time I hear them talk, I learn something. So I appreciate it. So, during the, especially in the earlier parts, both Beth and Chris talked about the project, and Beth in particular talked about the difficulty that she was been trying to look for data, and she can't find it in, I won't say she can't find it, but she can't find it in any form or format that consistently that allows fulsome searching and fulsome analysis. So our project grew out of, I think it was the first, or one of the very first conferences we had on consumer class actions. And we heard both plaintiffs' lawyers and defense lawyers get up individually, and the plaintiffs' lawyers would talk about the wonderful result that they got in XYZ case, and the defense lawyers would talk about, or the people who, not necessarily the defense lawyers, but people who were opposed would talk about how, some example about how terrible, or what they said was a terrible result. And out of that discussion, because we had a fulsome discussion about it, there was an agreement that we needed a neutral place, that there needed to be a neutral place to collect data and make it available widely. And that's what we undertook to do. I'm going to turn it over shortly to David. He can explain briefly some of the steps. But it has been, frankly, a very, very difficult road. And for reasons that we will explain. David, why don't you take it from that first thing and just mention briefly what happened out in the Northern District of California, and mention our discussions with judges, plaintiffs' lawyers, and then ultimately with claims administrators, and what how far we've gotten and what we're doing. Go ahead.
So we have, for a while now, been trying to procure the type of data that both Professor Burch and Mr. Seeger have been pushing for the availability of. And it's been a process of first figuring out where the data is, and then trying to make people understand the importance of it, and then figuring out how to get it out. So in late 2018, Sam Zakharoff went to the Northern District of California to give a little bit of a presentation about the importance of this data. And what we sort of had to explain was what a judge will say often is, I have the data, claims administrators have to file this PDF report at the end of every case, and it gives me the information I need to to assess what happened in that case. And what we've sort of needed to explain is that those reports aren't in standard formats. The information that's reported isn't standard. Cases, especially that aren't class actions, might not even have a comprehensive report in this type of way. And that if you want to do comparative analysis to say, like, okay, well, we know this amount was distributed, but how does that compare to similar cases? All a judge has to rely on is two parties who are already on the same side saying, trust us, this is great. And the judge doesn't have an independent way of comparing similar cases and comparing data in a more robust sense. And so the Northern District of California heard this and was, I think, somewhat excited about the idea of producing this data. And they actually updated their procedural guidance on class actions, and this is specifically on class actions at the end of 2018, to require additional reporting of information by claims administrators, including from some of their previous cases. Which is great, and I think is a step in the right direction. There are a few issues with it. One, of course, it's limited to the Northern District of California. Two, the amount of data that is being asked for is still relatively limited compared to what claims administrators collect. And three, they haven't required it to be reported in a specific template, which means that this data is still often reported via some sort of a PDF with a bunch of text in it, which makes it quite difficult to extract the information you need. So we would like to push on all of these directions, get these orders in more courts, get more data to be required, and to have it required in a standard way. So the step that we're going through right now is building data templates, and we're working with claims administrators to understand what data they store and how. One of the biggest obstacles we're running into is that claims administrators store different data in different ways, and some are very robust in the data they collect and some are very much not. And so we are trying to put together a template that a judge could order that most responsible claims administrators could comply with relatively simply and wouldn't be extremely high cost. In order,
interrupt David and say it's not just one template, but you could explain that.
That's correct. So we are doing a series of templates because I think, as has already come up here, a mass tort is going to look very different from a securities litigation in terms of the data collected, the data required, and the data we'd want to analyze. And obviously, consumer class actions are different, and antitrust is different. So we are developing a number of different templates to collect data in appropriate ways. But it requires a lot of cooperation and work from partners who are lawyers and claims administrators to help talk through what data is available, how that data is currently stored, and how we can put it into a template that's usable. So that is an ongoing project. If any of you who are attendees are interested in helping us with this because you have some knowledge of how this data is stored and some advice on how these templates could be structured, that would be very much appreciated. And we hope relatively soon to be able to roll out these templates to judges to allow them to issue orders such that data can be turned over in a standardized way.
And I want to say one very encouraging aspect of what we've been going through, even though it's been very frustrating because it's taken so long, is actually there are two. One is we have found a handful of claims administrators who want to do this. I mean, their basic idea is we understand that we could be made the bad folks in this story, and we would like to get this out, but we need the judges to order it because otherwise they think they face issues with their clients, who are sometimes the plaintiff's lawyers, sometimes the defense lawyers. So that's the first thing. The second really encouraging thing is on my board. We have, as you can see, if you go, some of the best, most accomplished plaintiffs lawyers and defense side lawyers around. And to a person, they joined together. They said, this is good for everybody. This was not an issue of, it's going to be good for the plaintiffs lawyers or it's going to be good for the defense lawyers. And so that was extremely encouraging. And that's it. That's what we wanted to say. And please send us an email. Did you put our email up there somewhere that they can send us if they're put your email up there. Anyway, it's David.Sifford. There we go. Okay.
Sifford@nyu.edu.
Okay, Sifford@nyu.edu. And so that's it. And once again, thank to everybody who has joined us, and thanks again to our panelists and our moderator. If we had any emojis here, which I'm not very adept at doing, I would put up either a couple of thumbs up or clapping hands, but we don't. I don't know what's wrong with this site, but I'm going to clap that. Thank you.
And to you.
Thank
Yeah.
you.
Thanks, Beth. Thank you, Judge.
Thank you.
Thanks, Peter. Thanks, David.
Thank you to everyone for attending. We very much appreciate your being here.
Yes. Still 82 people on.
I fell asleep.
Take care.